outside? Should I run and hide? How do I take my company worldwide? Do you love the law? Did you watch Hee-Haw? What's the weirdest thing that you ever saw? What's it like in court? Favorite sport? Can you help with my book report? Is my hair too long? Am I right or wrong? And do you mind if I sing along to anything? Ask Alan anything in the world.
Hello, everybody. This is Alan Crone, CEO of the Crone Law Firm, coming to you once again with Ask Alan, the podcast. And today my guest is a great Memphis lawyer and a great friend, Bill Walk. Bill is a personal injury trial lawyer. And I say trial lawyer because he tries cases. And that, in my estimation, that's what really makes you a trial lawyer. And it's I don't say it's a dying art, but it's a lot harder to get jury trials than when you and I were young lawyers, Bill.
Oh, it absolutely is. And it is a dying art because, with mediation, the cost of litigation, companies are real hesitant about going to trial now. So, it becomes more of a motion practice, litigation practice, and very few young lawyers get a lot of experience with juries. Like when we were young, we would go trial one or two a month and, get you, even if it was small car wreck cases, really, get your feet wet, learn how to speak on your feet and talk to a jury.
My wife's uncle was a lawyer here in town back in the day. His name was Edmondson. And he used to tell, it was actually her great uncle, and he would tell stories about the way he prepared for a trial. On the Friday before, he would go to the barbershop, get his hair cut and his shoes shined, and he would roll the file up and put it in his pocket, and that was his trial preparation. And he'd walk over to the courthouse and he'd try the case. And
Jim Cox, the famous med-mal lawyer, said the same thing. All it needs is shoe shine and a haircut to get ready for trial.
It's a little more complicated to prepare a case these days than that, but
a little bit.
Sometimes I think the quick justice, getting a quick trial date and just trying the case, there was a lot to be said for that.
I couldn't agree with you more. In general sessions, I tell you what, the other thing that's missing these days is general sessions court used to mean something. So when I started out, I did my first 12 years as a defense lawyer working for, an insurance defense firm. And we've tried cases every day over there. You have no discovery. You don't know what's going on. You got, a one-page complaint. So you had to learn to cross-examine. You had to understand proof, listen, and, fight that case. And it meant something over there at the time. So that really was a good aid. And nobody tries cases over there anymore.
Yeah, I know. If things were just the way it was when we were young, Bill, the world would be perfect, wouldn't it?
Well, yeah. But what I will give the young, what has improved, it totally changed my practice, and I'm sure yours, is technology. Has been so amazing. The fact that you used to have to work for a firm and used to have a bunch of secretaries and we dictated, and everything was so slow, and you had to print and you had to go down to the courthouse to file. So the technology we have now is amazing to me, to be able to email, to be able to electronically file, for us to be able to share documents so quickly. And people take for granted having a word processor. When I started out, I'm aging myself. When we started out, it was the purple carbon paper on a typewriter. And so if you made a mistake, you got to start all over. You don't just, press click and keep going. So
it was not long ago that, if you had a big motion in any court, really, you would, the staff would spend half of the day or more, the day it was due, collating and getting the exhibits together. The logistics of pulling it all together was mind-boggling. And now with electronic filing, you can work up to 11:50 at night and have it filed on time electronically without having to go through all of that. Technology is just it's a help and it's a curse at the same time, because it just speeds up everything.
Even depositions, though. In these medical malpractice cases that I handle, everybody would come to a deposition with 8 boxes of medical records. And so you've got carrying trolleys and people carrying all. Now you show up on a laptop. Everything is down on your computer, and everything's collated. So any medical record you need is at the tip of a finger, as opposed to digging through boxes. And you take it for granted, but that's nice to have.
The last old man comment I'm going to make is I do remember when I first started practicing at a venerable firm that Armstrong Allen, which is not around anymore.
It's a great firm.
Oh, it was a great firm. Lots of really good senior lawyers, particularly
Mr. Pruitt.
Oh, Mr. Pruitt. Now, Mr. Pruitt, my favorite thing, my one and only interaction with Mr. Pruitt, because I was brand new out of law school. He and I were riding up in the elevator together, and I never forget this, and I quote it all the time. And it was, I guess I'd been there about 8 or 9 months, almost a year. It was the summer. And he said, "Young man, what plans do you have for the summer?" I said, "Well, Mr. Pruitt, you know, my in-laws we're all going down to the beach." He says, "That's good." He says, "You can practice more law in 11 months than you can in 12. Now, I'm not sure that the middle-aged members of the firm would agree with him based on my billing requirements. But he made a good point. You know, you can overwork yourself.
I completely agree. And you need to be fresh. I think it's very important to take vacation time. I mean, the race is long. You and I have been doing this a long time. This is my 31st year. And truly, I have learned that you need to back it off a little bit. If you want to make it, it's a marathon, not a sprint. And if you want to make it, you got to take a week off. You got to go take a hike in the mountains or go down to the beach and, you know, smell the roses a little bit, because you'll burn out because we've both done it when we were young. Working those 60, 80-hour weeks just kill you.
Well, the last technology old man thing I'll say is, I do remember when my first year at Armstrong Allen, if you got a fax, they didn't call it a fax, they call it a telex.
That's right.
And they would literally bring it to you on a silver platter. They had a tray that was a silver tray that I think somebody had won. I suspect somebody had won at a golf tournament. And they would put it on it, and they would come into your office. Somebody from the office staff would come into it and be on that tray, and you would take it off the tray. That's how reverent. And so we went from that to, you know, you got a fax every 5 minutes to, I can't tell you the last time I personally got a fax.
Well, you haven't dealt with medical records. Hospitals are, like I always say, the hospitals are back in 95. People go, "Oh, I was going to, what's your email?" "Well, you can't email. We want a fax."
Well, I was quick to say personally, because I'm sure my folks on my staff who do that sort of thing get faxes all the time, but it's not like it used to be. Friday afternoon, you know, you would stand by your fax machine and you would get all kinds of, you know, late afternoon things.
Especially in domestic relations cases. It's always a Friday afternoon. I'm going to be in court Monday morning on you or something like that, or something.
Yeah, now they just email it to you, but it used to be the fax, and people would play games, they turn their fax machine off or whatever.
But I think it's good too to have, you know, I mean, you can be a slave to it, but to have access by email and text, I find it great. It saves a lot of problems with my clients. Is that I always give my clients my cell phone number, and I tell them, "Hey, text me, call me, email me. I would rather you not do it as, you know, at night or the weekends if it's not an emergency." But it's a lot easier for me if I'm in trial, if I'm in depositions, to simply tell them where I am and say, "Hey, I'll get back to you. It's gonna, you know, it may be a couple of days, but here's where I am." It makes them feel better as opposed to my lawyer's ignoring me. So I'd much rather take the time to return texts and emails than have a client feel like they're not being attended to or they're being ignored.
Yeah, I give my cell phone out pretty freely, and I tell them, "Look, you know, call me anytime. If I can't answer it, I won't answer it, but I'll call you back."
Right.
And I think people kind of respect that. I think some people, again, feel like they get it to slaves to it and never turn it off. I've started turning it off early in the evening, and I don't even take it upstairs with me. I charge it downstairs, and you know, there's a time in the morning when right before I leave for the office, I'll turn it on, see what I've got. So far, I have yet to be burned by that. And people seem to, it really doesn't matter what you think. People expect that kind of communication, not just with their lawyers, but with their doctors, with their veterinarians, with their, you know, with Kroger, I mean, with everybody. And the smart lawyer figures out a way to give that service, or he or she won't be in business very long.
So on that point, they've done a lot of research on medical malpractice cases and who gets sued and who does not get sued. and I can tell you just from my personal experience, it is not the doctors that perform worse or the least that get sued. It's the doctors who are not nice. It is condescending doctors who talk down to people, who don't respond to people, who act like they're below them. Those are the ones that get sued. I've had clients come to tell me, okay, here's our case. And I'll say, okay, we've got to sue Dr. X and Dr. Y and Dr. Z. And I'm like, Dr. X is really the one that did the worst. And he goes, no, I love him. He was so nice to me.
Yeah.
I'm not going to sue him. I want to sue the guy that was talking mean to me. Like, well, he didn't do anything wrong. Well, I know, but I just don't like him.
Right. Sometimes it comes down to, I call it playground justice.
Yes. Very.
Well, Bill, I'd like to ask a few questions about your background, just so people listening can understand who we're talking to. Where you're not from Memphis originally, correct?
No, absolutely, I am born and raised.
Okay. I'm sorry. Where'd you go to high school?
I went to Wooddale High School out in East Memphis.
Yes, I know Wooddale well.
Graduated in 1982 there. Played some sports and went to Memphis, and it's kind of a circuitous route to being a lawyer. I'd always wanted to be an architect, so I went to architecture school at Memphis, but it wasn't accredited. And I didn't really understand that until I was halfway through and realized it was going to be hard to get a license to practice architecture with my particular degree. So then I said, you know what, let me take the LSAT, and I became a lawyer. And I started out my first 2 years with infamous Robert Michael Fats Friedman. And so it was a great 2 years. It was pretty crazy, but I mean, we represented the criminal. I did everything. I was in every court. I was in probate, bankruptcy, 201 Poplar, the civil courthouse. And so I got my feet wet really early. And people at Hardison, which was a former insurance defense firm, I went against them a few times, and John Cannon, if you know John Cannon, offered me a job. And I went there for the next 12 years. And that's where I really, made my bones. I tried a lot of cases, did a lot of insurance defense work, defended doctors, used my architecture background. I handled a lot of construction cases, architecture negligence, construction negligence. I handled a lot of big cases like that, products liability, really got experience, and even did some medical malpractice defense. And so really was able to get a lot of trial experience. And then in 2003, I decided to go on my own because I really always wanted to do plaintiff's work. And it was a defense firm. So that wasn't really going to be a good fit. So I went on my own for just a couple of years. And then my former partner at Hardison, Robert Spence, former city attorney here, and I teamed up. And so I was with him for the next quite a few years, 10 years or so. And then since then I've evolved, and I'm now with the Walt Cook Lakey firm with John Lakey, Carl Jacobson, John Cook. And we've kind of got a nice little boutique firm. I'm the only one that does plaintiff stuff. Carl Jacobson does it with me. But we do a lot of work for the city and the state, domestic, a lot of corporate labor and employment, some that Carl does. But I focus mostly on catastrophic tort and representing, injured people in nursing home and medical malpractice cases.
Well, Bob Friedman certainly was one of the great characters of the Memphis bar.
I predicted his death.
Tell me your favorite Bob Friedman story.
So I predicted his death 24 hours before it happened. I was trying a case in circuit court. I was defending a case with Ivan Dave Harris out of Collierville. And he had known Fats Friedman. And we were walking around the hall, as you do when you're waiting on a jury. You got a lot of time to kill.
Yep. So
we started talking about Fats Friedman. And Friedman is one of those guys who was brilliant. The people that don't know who he was about 5'10", about 350. Big bushy mustache. He would chain smoke menthol cigarettes, dripping with jewelry everywhere, loud, boisterous, but a brilliant man and a charming man, except he would lie, cheat, and steal to anyone. I mean, he was that kind of guy. And even you knew he was lying to you, he was still so charming, some kind. And he wasn't always good with clients. And so I told Dave Harris, I said, Fats is so good. I said, but he has done so many people wrong. One of these days, someone's going to shoot him. It's going to be like an Agatha Christie novel. There's going to be 1,000 suspects. And literally within 12 hours, Dave Harris called me up and said, "You're a witch. Someone's gunned Fats Friedman down at the 100 North Main garage." But we represented a lot of the drug dealers. There was a family called the Bovan family here. Most of them are either dead or, in jail. And one of them, there's a famous local rapper. I don't know what your knowledge of rap is, but
it's encyclopedic. But tell me anyway. Tell me anyway for the listeners. Tell them.
Yo Gotti is a descendant of the Bovans. I'm not sure exactly how, but he's a descendant of the Bovans. They once gave him. He had a gold nugget ring they gave him, and the center stone of the ring was a green human eye.
Okay.
Yeah, I mean it was crazy. I mean we all drove cars that had been taken by the DEA, and we negotiated back, and Bob would take those cars as fees. I mean it was always, let's make a deal. We'd go down to the property, to all the property that had been seized from them, and it would be constant, let's make a deal on what the DEA was going to keep and what we were going to keep. But the good thing was it was a great primer on constitutional law. I mean, we handled a lot of serious cases, went to the Sixth Circuit Court of Appeals on search and seizure, and really was interesting. He, in fact, was involved, in that story, he was involved in that Dana Kirk case back in the 80s. He had one when, the whole gambling deal about the University of Memphis and whether Dana Kirk threw games. He had one of the other alleged gamblers in that case, and that was a pretty interesting case as well. So
he was certainly a member of a group of lawyers that every city had, that very few exist anymore, and that is the true big city general practitioner who, as you say, would handle criminal, handle personal injury, divorce, all, the whole gamut for his clients. That's very difficult to do now. I'm sure there are folks that still do that, but just about everybody else are like you and me, where they tend to specialize in certain areas.
I remember Frank Glankler. I mean, he considered himself, he was a lawyer. Frank Glankler was head of the biggest, one of the biggest corporate firms in the city, and he'd go handle a murder one case. I mean, and now this time, Leo Bierman, God bless his soul, just died the other day. I mean, that guy, he was a corporate lawyer at Baker Donaldson, but he could handle any kind of case. I'm convinced that he would. Brilliant guy.
When we first started practicing, I think unanimously he would have been picked as certainly one of the top 3 lawyers in Memphis, if not the top trial lawyer in Memphis. And if you didn't pick him, it was probably because you either were closely related to the second or third or fourth, also-rans in that. But he was another one that, as you say, God rest his soul, that was just a legend in Memphis. And those guys are now there's a whole new crop of legends, I suppose.
Right.
But
I've got a good Leo Bierman story. I think the statute of limitations is run, so I'm safe to tell that story. So this was probably 8 to 10 years ago. I was on the Tennessee Board of Professional Responsibility hearing panel. And to those that don't know, that's a hearing panel for discipline. If a lawyer's disciplined, they're entitled to a trial. And the panel is made up of other lawyers, and it's made up of 3 different lawyers. And you literally go into a courtroom and they put on a trial. The Board of Professional Responsibility puts on their case, and then the lawyer is able to defend him or herself. In this case, I was the chairman of the panel, of the 3-person panel, and Leo Bierman Jr. was the counsel for the accused. It was a female lawyer. He was the counsel for the accused. And what it looked like it really ended up being was it was a domestic relations case where, in my view and that of the panel, the complaining lawyer was really using this bar complaint more of a litigation tool than it was true, malfeasance. And so the board put on their case, and Mr. Bierman did a great job of cross-examining and really establishing the case and really poking holes in it. And so after the board got through, Mr. Bierman made a motion for directed verdict. And so we go back to discuss it in chambers. And we all agreed that, the motion for directed verdict was well taken, should be granted. But I was able to convince the other 2 to hold off. So I kind of want to hear Leo do a closing argument. I said, free. I said, we know what we're going to do. Hey, why don't we deny this and at least let me have a free lesson here? So we denied it. And Leo, of course, did a brilliant closing argument. And it was like, man, that was a lesson for me. I later told Leo that story. He just shook his head and had a kickle because it's kind of a compliment. So he was great. I mean, absolutely fantastic lawyer. Loved. The other one that comes to mind, I tried a case against the great Houston Gordon. And to those, I know you know Alan, but Houston Gordon was a famous lawyer, a famous trial lawyer. He first came to fame in the My Lai massacre in Vietnam, where he was one of the lawyers that defended Lieutenant Calley. And he has been just an incredible lawyer ever since then. A great plaintiff's lawyer, great lawyer. He would do everything as well. And I was a young defense lawyer. And I had a case against him where I was defending a car wreck. And it wasn't a big case, but we tried that case. And it was the greatest lesson I've ever had in my life. It was more than I ever learned in 3 years of law school. I mean, watching him try a case. And I remember having to go around the jury box after he got through with closing. And I wanted to pull out my checkbook and write him a check for everything he asked for right then. He was just so great. I mean, it was just, what a terrific lesson it was to learn at his feet. He was just so, and we talk about Leo Bierman, two totally different styles.
Right.
Both of them incredibly effective. Houston was more of I don't want to call him a preacher because that's derogatory. I mean, it sounds derogatory for a lawyer, but he was more colloquial, more of that Southern charm, where Leo had more of that new Northeastern, and he was so precise and so succinct with his words that, I mean, it would just take a few words of him to cut right to the core and to the bone to make his point, where Houston had a little bit more of a flourish about him. Both of them just absolutely brilliant lawyers. And I value being able to have participated with both of them. It's amazing.
My Houston Gordon story, I don't even remember too much about the case, but he and I had a case together. We were on opposite sides of the case, and we're going to take a deposition. Or I think, we were going to take a deposition. And he calls me up. He says, "Crone, I can't come to the deposition, but I'm going to send an associate." And so the deposition will go forward. So I hung up the phone. I thought, man, I'm in good shape. I'm not going to have to sit across the table from, as you say, the great Houston Gordon. And who walks in? His associate was former Chief Justice of the Tennessee Supreme Court, Lyle Reed. So it was
fire to the frying pan.
Yeah, it wasn't the relief that I thought it was going to be. But I came home and I told my wife, who, as you know, is also a lawyer, that story. And she said, well, that's one of the few times where you don't lead a charmed life, Alan.
Oh, wow. Yeah.
Well, it all turned out okay, but that's my Houston Gordon story. His associate was
associate Lyle Reed, former Chief Justice Lyle Reed. Yeah. Man, he's still just beautiful lawyer. In fact, in that case, it sounds terrible, but I have to tell you what I told him is his demand was 60. He tried to get 60,000 from the jury, and the jury only gave him 20. We had already offered him 25. So in defense firm parlance, that was technically a victory. But I was so concerned that Houston would think somehow I thought I had done something. So I said, I'm calling him Mr. Gordon. Mr. Gordon, I just want to make sure you understand, I know who the lawyer in this courtroom was this week, that I take nothing from this. I know who the lawyer was. So please take my compliments and know whatever they did, but it wasn't because of anything I did. So he was that
was the right thing to say to him.
Oh, and it's the truth. I mean, it wasn't hard to say. I mean, he was so good. The other thing that I learned about stereotypes, and one of the first cases I had at Hardison was with David Cook, great trial lawyer. And we were in a huge construction case involving Counts, Tennessee, the paper plant, a turbine generator blown up. And so there was all kinds of insurance companies. There was Westinghouse. There was the engineer, the contractor. It was just huge. And these two Chicago lawyers represented the plaintiffs, the paper company. And we had one of them. I mean, I was with David Cook, General Al Harvey, and Robert Moore had one of them. And then Westinghouse was represented by this Washington, D.C. firm. And this lady had handled the entire case. I mean, this case had gone on for years. And we got into the courtroom. Janice Holder was a trial judge. We got into the courtroom, and there was this guy named John Ferguson who was going to try it for Westinghouse. And I've been practicing 3 years. And I'm looking at this guy. I'm like, this guy's never been involved in this case. He doesn't know any of this. Here this guy's coming down from D.C. He's coming to the South. I'm like, oh my gosh, he's going to get his hat handed to him. I mean, this is going to be disastrous. And 5 minutes into his voir dire, I said, this is the best lawyer I've ever seen in my life. 5 lawyers into it, I'm like, oh, it was such a valuable lesson of don't judge until you've actually heard somebody. He was brilliant, absolutely brilliant, and did a great job. And it was a case.
Well, you've had a great start to your career. The first 30 years have been
Yes.
great. It sounds like you've had lots of different kind of experiences. What I always like to ask lawyers this: what's your favorite moment to you in a courtroom?
I can absolutely, I can tell you this without even having to hesitate. I was trying a case as a plaintiff, and I had not tried that many medical malpractice cases as a plaintiff. I'd lost one, and I was trying a case with Regina Guy against Bill Dunlap. Great, he's retired now. He was a great lawyer, Harris Shelton lawyer. And we had a case involving a little baby that had necrotizing enterocolitis. And we had tried this case, and NEC is you get a hole in your bowel and then food gets in there and you end up getting septic. And so the treatment for it is to run serial x-rays. And, so you keep looking at x-rays to see if there's any free air, to see if there's any. And so we had gone on and on with these experts, and the neonatologist had read the x-ray incorrectly. And he missed it. The girl had an anoxic brain injury, ended up having cerebral palsy. Luckily she lived, but she was just completely impaired. And so I waited until the very last expert because I didn't want them to be able to correct that. Because the only thing in that note was, he said his whole memory was a note. I don't remember anything about this except the note. And he said no free air in KUB x-rays, which is kidney, utera, bladder x-rays. And his last expert got on the stand, and I rolled the dice to wait for the last expert. He said, man, he did everything right. Even if he misread it, he did what he was supposed to. It was right. And he didn't see it coming because I got him to admit that the gold standard and the standard of care required him to run LLD x-rays instead of KUB x-rays, which sounds like a technical point, but this guy barked so much, everybody had barked. And this expert, this Vanderbilt former military guy who had just been yelling at me, all of a sudden realized. I walked to the corner of the courtroom. I was as far away as I could. So, doctor, tell me, did he read the right x-ray? No. He read the wrong x-ray. So not only did he not order, he ordered the wrong x-ray. So there was no way he could have read those properly because he didn't order the right x-ray. And the only Perry Mason moment I've ever had like that, I put his head down and went, yes, he ordered the wrong x-ray. And so by that definition, your definition, he departed from the standard of care, didn't he? And I'm screaming from the far side of the court, yes, he did. And so we go in, we do closing, and I'm like, man, I've just killed this. This case is over. It took 3 days for the jury to deliberate. And I'm like, I'm in the dark place. I'm sitting out in the hallway. Alan knows what the dark place is.
Yeah.
I'm like, I can't do anything better. I can't try a case better than this. If I can't win this case, I don't need to be a lawyer. If with what I just did, if I don't win, I'm terrible. I don't know what I'm doing. And so day 3, the jury comes and asks for a question. That's common. They ask questions. Can we go home? We're stuck. Can we leave? And you're just. So I had my head down, and I'm just so depressed that I put all this time and effort, and I'm about to lose this case. And I put my head down, and Judge Stokes gets the note, and he said, the jury's got a question. No, wait a second. They have a request. They would like a calculator. 30 minutes later, they came back with a verdict for $12.3 million. So that's that's easy to put a finger on. Favorite moment as a lawyer is that right there? $12.3 million.
That sounds like a good one to me.
It was a good one.
Good one to me.
It was a
You know,
good day.
I thought if that had turned south on you, you know, sometimes and you did a good job, it sounds like, of highlighting it, but sometimes Perry Mason moments are usually valued, because a lot of times it's the repetition that you need to really establish it with the jury. Sometimes if it's just one moment, you know, 3 or 4 members of the jury may miss it.
Right.
The way you did it, it was probably hard for them to miss it, but
and you have to set that up just right. And so, but I learned. Let me tell you, if I may tell you, one of my failures as a trial judge or as a trial lawyer. I mean, that's one of the things that I learned. You learn a lot from your mistakes and your failures. In 2010, I was trying a case with Regina Guy, lovely lady, and we had a black lady who had gone blind during her C-section because we believed that the anesthetist let the blood pressure get down too low and she'd gone blind. And during jury selection, there was a black nurse on the prospective panel. And Regina was insisting on leaving this nurse on the panel. And I disagreed, because you don't want anybody in healthcare against, you know, as a plaintiff, they're going to side with them. And Regina felt that her race would connect more with our client, Regina, and that somehow she would give special treatment. And it ended up not being the case. So what happens is we try that case for 2 weeks in front of Judge Childers' courtroom. We tried as good a case we could. The late Bill D'Amico's on the other side. He did a good job, but we tried a really good case. In fact, the closing was done on Friday. On Thursday night, my wife was due to give birth the next morning at 8 o'clock. I'm like, Judge Childers, my wife's, you know, being induced at 8 o'clock in the morning. Can we wait till next week to do closing? I said, no, I'll give you till 11 o'clock in the morning. So up all night, deliver the baby. I didn't deliver it, but I was there for the baby being delivered at 8 o'clock in the morning. Have enough time in the snow and ice to go shower, walked in the courtroom, Mr. Walk, closing argument. and my wife had just had a C-section. So I was just obliterated. I was crying for the first 15 minutes of the closing, because it was such an emotional event. And this poor lady had this happen to her. It was terrible. And the jury came back late that afternoon, and they came in favor of the defendant. And several jurors emailed and called me afterward and said, hey, it was 8-4 in your favor when we first went out, but that nurse on the jury, she picked us all off. She was able to talk medical jargon to us and argue with us. We had no response for that. So we finally just caved in. But that nurse is what caused us to, we couldn't fight her. So that's the old Bill Parcells line that I've used since then. It's like, look, if I'm going to cook dinner, I'm certainly going to buy the groceries from now on.
I had an old lawyer tell me once, you learn more from the cases you lose than the ones you win.
Absolutely.
And that certainly is the case. My one story on jury selection, I was local counsel it was a national origin case. And I think it was one of the last cases Judge Bernice Donald tried as a district court judge. And it's about 10 years ago. And what was interesting about the case is our client was from India, and it was national origin. And we're going through jury selection, and I really was. It was a great learning experience for me, because I was local counsel, and for those non-lawyers, that means I was the guy from Memphis, and the real lawyers, the lead lawyers, were from D.C. And I knew them through some bar association things, so they asked me to be their local counsel, and so I was there for the trial, and I didn't have a whole lot of responsibilities. I was just there. Well, one of my responsibilities was to help them with jury selection, and we get down to the end, and we had one peremptory challenge left, which is a peremptory challenge is a challenge where you can take somebody off without really having a reason. Can't have an illegal reason, but you don't have to have much of a reason. And there was an African-American lady. I think my recollection, she was late 50s, early 60s. And they wanted to keep her on because they thought it was a discrimination trial. Well, she would be an advocate, and some things that she had said made them think she would be an advocate. And they said, "What do you think?" And I said, "That lady has seen real discrimination. She knows people who had dogs sat on them, fire hoses sat on them. She couldn't drink from water fountains. Our guy didn't get a job because of his national origin. And he didn't have that kind of story."
Spot on.
And so I said, knock her. We knocked her. And the person we put on was our biggest champion, as it turned out, in the jury room. Now that I didn't know was going to happen,
right.
but sometimes, you like you say, you got to go with your gut. And, who knows if we'd left her on, what would have happened. But I've taken credit for that verdict many times, because I really don't think that woman would have been buying what we were selling.
I just think people make a mistake in the city of Memphis. Everything's so race-based.
Yeah.
They make the mistake, some lawyers make the mistake of looking at blacks as a monolith, as just a single, that they all think the same, that they're all liberals. They're all, we're going to be sympathetic to a plaintiff or whatever. And it's just not the case. Many blacks, especially black men, are conservative, have a very conservative background, very religious, very conservative. And so you have to treat them as individuals as you would white people. And so just by virtue of saying, it's very facile to say, I just want black people in my jury. I just want white people. It's really not that simple. You've really got to take each juror, whatever their color is, on a case-by-case basis, and not assume because of their color that they're going to be a certain way. You never know. It's always a surprise to me. I've tried more jury trials than I can count, probably 80. And you never know, who's going to be the foreman, how they're going to, the guy you think's liberals, conservative, and vice versa. It's like you never really don't always know. And let me tell you, as far as jury selection, what's really helped us is being able to use social media. So we'll keep somebody back at the office. And so as soon as we get the jury list, we shoot that over. Because I've had guys in there, like I had a case where I had a Mexican immigrant, and one of the guys on the jury looks like just this regular dude, just a little regular white guy. And you look on his Facebook page, and he's got machine guns and rebel flags and all kinds of, terrible racist stuff on his Facebook. And I'm like, man, we got to get this guy off of here. But I wouldn't have known it but for someone back in the office running social media on him. So, it's jury selection is something else. It really is interesting.
In these big cases, do you use jury consultants?
So what I have done, I don't in the courtroom, what I have done on several big cases is used focus groups before trial. So it kind of helps us develop a profile on what kind of juries we want, or what kind of specific juries we want, or what we don't want. If you've got if the case is big enough, it's worth the resources to really try it out with a focus group. And people do a really good job in the focus groups of really, you get to put your issues, and they're able to look at, okay, how is this wart going to play, or how do they feel about certain issues? And it is fantastic to be able to watch them analyze, because we think we know what's important and what's not, but it will amaze you what some people focus on that you thought was a minor issue or not an issue at all. And the big issues are like, no big deal. So those are really nice to do. I used to get to do a lot of them as a defense lawyer, and I found them so helpful. I had a rape case one time where it was at an apartment complex where a lady was brutally raped in her apartment. And so the plaintiff's proof was that, wasn't adequate security. And our proof was this guy was on a crime spree. There was nothing you can do to prevent this guy. It was, it didn't matter what you did. This guy had committed a bunch of crimes. He had a big history, and he'd been doing a lot of. And so we ran it through a focus group. And it really was true that the jurors thought, well, why didn't that guy on trial? Why didn't the guy that did the crime on trial? And so most of the focus group did not want to give a lot of money. But the insurance company it was a tough case. The victim was such a sweet, nice lady. So you were so empathetic to her. They end up paying, and we settled the case. But that was one that I was always interested to see what a jury would have done had we gone to trial. It was a really interesting case. A lot of those cases we settled, Alan, I'm glad we settled them, but it's always, some of them are very curious. You'd love to know how a jury would handle certain cases. I mean, I'm always, every time I settle a case, I can't help but scratch my head and go, what would a jury have done on this one? So,
well, and the fact is, you don't know, and you don't know. You could try a case, and you know what that jury did with it, but you don't know what the next jury would do with it. You know,
correct.
And I think that's what is hard to sometimes educate non-lawyer clients, that there's right and wrong, and then there's what happens in court. And
correct. And what you can prove, what you can put before the court, what you cannot. You can't put what you think happened before the court. You have to think what you can prove.
And you just never know how people, like you say, you never know how it's going to strike them. And one little fact that you think is, you know, kind of a throwaway, someone may seize on in the jury room, either because they have an agenda or because it just strikes them. And once that happens, there's nothing you can do about it, because the lawyers are sitting out in the hall. You know,
they judge a lot of times a plaintiff. I've said this a lot. The lawyers are allowed to be jerks and not nice and all that, and because they're like, it's a lawyer, they're expected to. But the plaintiff or the defendant is not.
Yes.
But just to give you a story, if you've got time for this story, what jurors will do. I had it's what's called a res ipsa loquitur case against Bill Bomar, Blankler Brown. And my good friend Rob Hale was also co-defendant. And what it means is the act speaks for itself. So we had a baby, just to be really brief about it. We had a lady who delivered a baby who was completely healthy. It was delivered in 7 minutes. The abgars were perfectly normal. There was no scrapes. There was nothing wrong with this child. She holds her baby. She looks at the baby. And because she had what's called meconium, which is like the baby pooped a little bit in the womb, and they had some on her. So just as a protocol, they have to take the baby down to neonatal just to make sure it's okay. That was it. Nurse comes in, neonatal, takes the baby away. It took her 12 minutes to get from the delivery floor, one floor up, with a key to the elevator. When the baby got up there, the baby was bruised all over the head, broken ribs, distended belly. The baby lived 30 days. And the first time the mother held the baby was when they pulled the plug for the baby to die.
Oh no, that is a terrible story.
It's terrible. So, and their medical records were changed. By the time we got the medical records, one set of records had one abgar, then they had them crossed out and they changed them lower. They had whole notes that were changed. We had 4 or 5 examples of medical records changed. I got a nurse on the stand to admit I changed the records. I've never done it in 30 years. I did it this time, and I don't know why. Overwhelming case. The defense was the baby came out that way. There's no way he could have gotten bruised that early. The prenatal strips were normal. There was nothing prenatal to indicate that there was any problem whatsoever. Term baby, no indication. So we tried that case. The case goes to the jury. It went great. The case goes to the jury. I had a mediation set on a previous case. Of course, plaintiff lawyers were always trying to hustle. And so Regina Guy, I was trying that case with her. I said, hold the jury. If there's any questions, just take the verdict, whatever. There's not much that can happen. So I got through with the mediation. It's late in the afternoon. I'm in Germantown. This is true story. And, I know what Mark Twain says about anytime somebody starts off with a true story. I call up and the associate, Brian Meredith, he's on the phone. He's going, it's gone crazy here. I'm like, what are you talking about? At 4:30, the jury gave a note to Judge Karen Williams. And the note says, and I quote, more than 2 jurors believe they saw Mr. Bomar call us effing idiots. And we want something done about that. Paragraph. We want to quit for the day and we would like the exhibits, just to go back tomorrow. Judge Williams would not poll the jury. Like I've had jury issues before, and you poll the jury and you say, hey, can you still be fair? We don't think he said it, whatever. Can you still be fair? She wouldn't poll the jury. She made a judicial finding that there's no way Bill Bomar would have said that. And that, but I'm also making a judicial finding that the jury's now tainted. Mistrial.
Yeah.
So the next year, we tried it again. A jury of all 12 women. And you know, the second time is not nearly, well, it went well, but they're ready for all your stuff the second time. 12 women, and we went through the whole voir dire process. And after 2 days of deliberations, they were hung 9-3. Judge Williams said, hey, do you want to keep deliberating or do you want to go home? And my line on the record was, that's like asking an 8-year-old, do you want to do your math homework or do you want to go get ice cream? Which one do you want to do? I mean, that's not really a question. So she hung that jury up. When we talked to the jury, it was 9-3. The 9 people wanted to give between 10 and 15 million each. Because it was hung, we got nothing.
Mm.
One of the ladies on the juror was hung was a grandmother who had not, we'd asked her extensive questions in voir dire. She didn't say anything about it. She said, well, you know, something happened to my grandson one time in the hospital and nobody did anything about it. So I don't see why why this child has something done. That was a basis she held for 3 days on.
Right.
She held the other 2 people. Eventually the case settled, but it's such a crapshoot. The statistics on medical malpractice cases, the ones that go to verdict, return verdicts for the defendant, doctor, or hospital 80 to 85% of the time in Tennessee. It's that conservative a state.
Yeah, it is difficult. Any case is difficult. Any case is unpredictable. And if a lawyer tells you that he or she knows how it's going to work out, they're not being truthful with you. Because, you know, both of those stories you just told, not unusual in many respects in terms of, you know, it really does, you know, it's not unusual. You know, a different judge may have done it differently, but probably in the first instance, you know, that if 2 jurors believe that, it is probably a mistrial.
Hey, and if you ask me, do I believe it? I know Bill Bomar. I'm not going to say I don't believe it. I'm not going to say, and he's a friend of mine, but I'm not going to say I don't believe it.
Well, I'll leave it at that. I'll leave it at that.
And when I hear a lawyer say, they've never lost a case, my first thought is, well, you haven't tried very many. And if you have, you haven't tried any hard ones. So anybody that claims they've never lost hadn't tried a tough case.
Or they have a very broad definition of winning.
Yes, exactly.
Well, Bill, I appreciate your time. I appreciate you being on the show. I've enjoyed it. I've enjoyed the stories and the personalities that you've brought to life. And if anyone out there needs a trial lawyer to be your champion, Bill Walk and his firm they're great and they'll do you a good job.
Hey, thanks so much for having me, Alan. It's been a pleasure.
All right.
Always a pleasure talking to you. Thank you.
All right. Well, you're welcome. Just tell everybody, if you've enjoyed this, please forward it to a friend or share it. If you're watching it on social media, please go to the Crone Law Firm and like us on Google or give us a review on Google if you enjoyed this. Very, very helpful for us to get the word out if you interact with us on social media. Again, this is Alan Crone, CEO of the Crone Law Firm. Until next time, we're going to be getting justice for our clients, just like Bill.